Hello, everyone. I'm Emma Morgan. I'm an employment and immigration partner at Shoesmiths. Welcome to our 7th podcast in our 8-series podcast about compliance and risk management. We've been exploring various aspects of compliance and risk, and today we're delving into investigations. Today, I'm joined by my colleagues Darren Allen and Rebecca Cockcut, who will be sharing their insights and experiences of investigations. So, Darren, in our recent litigation survey of about 360 GCs and senior lawyers within large businesses, 50% of respondents stated they've been involved in regulatory disputes in the last 12 months, making it their most commonly occurring type of dispute. The increasing complexity of managing compliance across areas such as financial services, data privacy, ESG, competition, employment, immigration and consumer protection means that it has never been more critical to adopt a strategic approach to managing risk. So in response to Shoesmiths, we've launched a compliance and risk offering, which looks to provide clients with assistance around the regulatory life cycle. So Darren, would you like to talk a little bit more about it?
Well, so it's from the investigations perspective, we looked at, as you said, the life cycle of a regulatory issue. And so we talked about horizon scanning and what's coming down the track in terms of legislation. We looked at them putting policies and procedures in place, audits, and inevitably when issues go wrong, you'll have investigations and you might flow into regulatory issues and litigation, defence, and then how to then deal with that from a public affairs perspective. So our focus today is on investigations, which I think is a critical part of that regulatory cycle.
Mm-hmm. Great. Rebecca, would you like to add a little bit more about that?
For sure. I think one of the first things we should do on today's podcast is really think about what we mean by an investigation. I think in this podcast and more generally what we're really talking about is an investigation which falls in either one of 3 categories. So the first is an internal investigation. And what I mean there is when an organisation has identified some suspected or inappropriate misconduct which is taking place internally and needs to be investigated. And then the second category is one which would fall, I suppose, under the regulatory head. So that's where an organisation or regulatory enforcement body like the Financial Conduct Authority, HMRC, have started to ask questions about something that it may have happened at the organisation. And then the third and final category we're talking about is a criminal investigation. So that's where an organisation like the Serious Fraud Office, or again HMRC exercising its criminal powers, has identified some criminal wrongdoing at the organisation and want to get to the bottom of it.
So thinking about internal investigations, both of you, just in terms of giving practical tips to clients, what sorts of things would you suggest when we're dealing with internal investigation? What top tips would you give to our clients?
The first top tip I would really encourage people to think about is to stay focused on what it is that your investigation is intending to achieve. It's really easy once an investigation starts for it to take on a life of its own and it can become sprawling.
Yeah.
But I would encourage people to be as disciplined as they possibly can be to make sure that they're able to achieve the outcomes which they set out to achieve at their beginning. That would be my first top tip.
I think that's really important, because if you don't do that, you can just go off at tangents. You may not deal with the key issues which you want to deal with as a matter of urgency, and it becomes time-consuming and expensive. So it's really important, as you say, to scope it at the start, so that everyone knows where they're going and everyone knows their role as well. And there are. I think there's a whole raft of things that you would automatically think of when starting an internal investigation. Forming an investigation team, who's going to investigate? That is not an easy answer, because some companies will have an internal investigations team itself, and the third line of defence might investigate. You might get an external consultant, external law firm. There's all sorts of considerations which flow from the way in which the team is structured. For example, just giving you one example, if it was a matter that required forensic accounting, you might instruct a firm of accountants. That will be an appropriate way to proceed. However, you'd need to be aware of the fact that accountants have reporting obligations under the Process Crime Act, and you might find that your investigation has been reported without you knowing because they couldn't tell you because that would be tipping off. So there's just thinking through, the consequences of your actions when forming an investigation team is really important.
I agree with that, but always it is important to come back to the fundamental proposition, which is that your investigation team is independent and impartial and kept separate from the underlying misconduct which is to be investigated.
Yeah, up to a point, because of course it depends on the nature of the investigation, and you do have circumstances where third line might be investigating because it's cheaper, convenient, and they know they know the issues and often the people that are being investigated. So I think it depends on the size of the issue. But I don't disagree that in an ideal world, having an independent investigation is better.
Well, perhaps that goes to what the purpose of your investigation is at the outset. I mean, one of the things that Darren, you and I have thought about a lot in some of the investigations we're doing is what might the end result look like, and in particular, might our client ever end up in a situation where it needs to consider reporting to law enforcement or authorities? And then in that case, then you perhaps might need to set your investigation team up.
That's different. And I suppose that also leads into litigation, because I know certainly in the employment context, you might then have to think about, well, who would then deal with the next stages of the process and who ultimately will end up giving evidence if we did end up in litigation, because that is also a big factor when you're thinking about who do we involve in this process.
Yeah. Well, Emma, the other issue that Rebecca touched upon was notifying the authorities. The first question, particularly in relation to potential criminal wrongdoing, is should we tell the police?
Yeah.
And that in itself is a really interesting question, because the answer is that you have no obligation to tell law enforcement. You might have an obligation to tell regulatory authorities, like the FCA and so on. And you might also want to make a self-disclosure to the SFL or others in time. So it's quite a complex issue that you need to think about very carefully, usually at the outset of a matter.
Similarly, that factors into an immigration one as well, where it comes to compliance. Sometimes we have to report ourselves as well. In terms of the client thinking, well, I need to report ourselves to the UKVI, the Home Office, because that is, again, another point in time where you think, well, okay, do we do this? Does this make us look better? What else can we factor into this? What other corrective action can we take? So you're right. There are lots of different things that come into that reporting and that thought process in terms of the investigation.
Or from an employment perspective also, and I would often liaise with you and your colleagues in relation to this, but do you suspend employees that suspected of being involved in wrongdoing? Can you suspend them? Do you have the ability to do so?
And are you using suspension in the right way as well?
Exactly.
So Darren, you've got your investigation team ready and raring to go.
Yeah.
What do you next do when it comes to planning and scoping any investigation?
Well, we've mentioned putting together the investigation team, which is very important. Who is going to investigate? And part and parcel of that will be, do you cloak it in legal professional privilege? Is legal advice going to be provided? Is it in contemplation of litigation? So that's a really important consideration. It's not one that necessarily has an easy answer, because very often companies will have their own investigations teams that do not have lawyers within them, and they're much more comfortable doing the investigation on their own or without the protection of legal professional privilege. So that's a consideration. The other thing is timescales. Emma, you and I talked about suspending employees, but you can't suspend them forever. So you need to have a very clear timescale as to when you're going to interview witnesses, how quickly you're going to gather the evidence, both physical, electronic, how you're going to deal with the data protection issues that relate to the gathering of evidence and so on. So it needs to be a proper plan at the outset that where there's accountability as well. So people that are required to do things know that they're required to do them, and by a certain time.
Yeah, because the other factor in all this, we often say, is that people have got their day jobs to do as well. So when you're looking at your team and when you're going through the exercise, it's making time for these things. And that can often be the hardest thing, because, well, I've got my day job and I've got to do this investigation at the same time. And there's obviously lots of things you've got to factor into that, making time for things. So you're right, in terms of timing, that isn't one of the biggest things, I think, in employment, certainly in internal investigations we deal with.
Yeah.
Some of them can drag on for months. And obviously that is not good for any business anyway as well.
Well, let me ask you both the questions. So when you're interviewing witnesses, how do you go about the interview process, and do you allow legal representation?
That's a start. I was going to say, in the employment, we try and avoid having the lawyers involved, because it often makes things much more adversarial. So if it's a sort of sexual misconduct case, harassment, that kind of thing, generally speaking, you're not going to have lawyers involved in the actual interviewing process unless you choose to use an external law firm to investigate the complaint. Yeah. But generally speaking, you wouldn't be offering people necessarily a lawyer. But having said that, if there are criminal proceedings alongside, the individual might ask for that. But sometimes I think, certainly when you're trying to go through a complex investigation and you want people to feel comfortable talking openly, sometimes lawyers can make it more difficult, because it becomes more of a courtroom battle rather than actually what it's intended to be.
Yeah.
I think when it comes to interviews, you can never be too prepared. I really have found over the years that organising your witness interviews in such a way that means you deal with arguably the least senior people first, so that you're able to gather as much evidence before you get to the people who most closely bind the company or are most important to the company, is really helpful. Likewise, if you're able to review contemporaneous evidence ahead of those interviews, I find that's really useful. Then you have the opportunity there and then in front of the individual to test their account, or equally to remind them, that you can jog their memory by showing them contemporaneous evidence, and that itself makes your interview and your fact-finding exercise much more productive and more useful. I also think when it comes to running through your interviews, to be mindful of your privileged position, as Darren, as you mentioned at the start. So always taking care to give the right privilege warning at the outset, so the individual understands that the interview is privileged, and then who that privilege belongs to, and that they may have the opportunity to waive it. And when it comes to whether individuals have their own legal representation, of course, that's essential, certainly when it comes to the defence of any criminal inquiry. And I think a company has to always be really mindful of the sort of organisation it is. If an individual does want legal representation, I don't think it's ever particularly attractive to be the organisation that says no. And he may be, in fact, forced to cover the legal costs of that interview. But as the company's lawyer, always you must bear in mind that you're acting in that company's best interests. And if you have to press on with that interview and the employee is under an obligation to meet its duty of candour, I think it is an employment, is it candour, or I forget what the employment law obligation is, duty to cooperate or what have you, or maybe there's obligations in its employment contract to be interviewed, then you must press on and speak to that person and get the information that you need in order to get to the bottom of what you're looking at.
I think there's always the duty of fidelity, and there's also the implied duties in the relationship. It depends on the fiduciary duties, depending on how the senior they are in a business as well. So
I tend to find myself in your camp, Emma, where I try to exclude lawyers, but actually increasingly, particularly in financial services investigations, it is a question of you either agree to a lawyer being present or you don't interview the individual, and you want to get to the bottom of it so you can find out what the issues are and whether there is an issue there for the business. So often you have to agree to it. And sometimes, actually, to be fair, lawyers can assist the process as well, because they will properly advise their client to cooperate with the investigation.
I mean, in employment, we are used to having some form of representation in meetings. Obviously, individuals will often bring a trade union representative or a work companion or something. So we are used to that. It's just trying to, as you say, you've got to investigate something, so you want to facilitate it and make sure it happens. Because if you put too many obstacles in the way or refuse unreasonably, then the process is not going to progress in the way that it should. So,
Darren, you mentioned gathering evidence and getting the documents together for your investigation. What would be your top tip there?
Oh, actually, there are quite a few things that need to be done in relation to gathering evidence. But first of all, preserve evidence. So, companies will have document destruction policies. Stop that to ensure that evidence is preserved. Identify key custodians that will have evidence and undertake electronic searches. But then also think about the data protection issues around that and the extent to which your search for documents is relevant and proportionate and in accordance with data protection legislation. And don't forget physical evidence. I mean, I've had a number of investigations where physical evidence is still actually has still been relevant. So those are my those will be my top tips when gathering evidence.
Yeah, because I think sometimes when gathering evidence, people can sometimes be reluctant to provide it. That's something we find in employment, certainly. And obviously trying to persuade people to provide that, but also, making sure that people keep things. DSARs, data subject access requests, are a big area now in terms of compliance. And often you might find when you're going through this process that there is going to be a DSAR, or there already has been one. So that often means there are more documents available to you, which makes it a little bit easier.
Well, it's probably a subject for another podcast.
That is definitely one.
No, but I mean, as part of our investigations, inevitably we will get a DSAR request from somebody who is suspected or may be involved in an investigation, and then the question of the extent to which you disclose the information in relation to your investigation is quite a hot topic. But that's, as I say, it's a subject for another podcast. I mean, coming to reporting, so you've done the investigation, then you have to report to the client. How would you typically do that?
Depends so much on, I think, the matters to be investigated and also the client preference. So in some instances, of course, clients may want, and it may be appropriate to do a full report, written report, hopefully privileged, but it might be a written report. In other instances, it may be more appropriate to have an oral update to the board of directors. Maybe that's done with a slide deck of key points to note. Reporting, I think, often we think about that being at the end of any investigation, but certainly in investigations I've been part of over the years, there's been more of an expectation of interim reporting. And so that you don't leave everything all until the end.
Often in the employment context, the internal investigation is actually the start of what might be then a disciplinary process, which may lead to someone leaving the business, or it might be the start of a very detailed and complex grievance process as well. So, it can be kind of the start for us. And often those reports are something which we would expect to be disclosable.
Yes.
And therefore, if you are going to launch into that, the problem being is that you might uncover lots of things that obviously then end up in tribunal later on. So again, that goes back to your initial point about what are you trying to get? What's the purpose of your investigation, and what is the likely result of that investigation as well?
Yeah.
So thank you very much. That's been brilliant. So if you want to find out more, visit our website where you can learn more about our compliance and risk offering, and you can also listen to each of the podcasts in the series. So thank you for tuning in.